Go, Filippo.
Wonderful. Thank you very much, and welcome everybody. Good afternoon, wherever you are. And it is my pleasure today to chair this event. And it is really, really a wonderful opportunity to host today, primarily Professor Daniele Gallo, Luis Rome, who is going to be presenting his latest monograph called The Direct Effect in EU Law. It's a very niche topic you might have not heard about, but I'm sure that Daniele will be able to explain what that is. Now, I'm not alone today, and Daniele is not alone, and that's why I need to thank the organizers, and in particular, Professor Martinique and Professor Delle Donne, our friends at STALS, for giving us the platform to organize this roundtable. And together with Daniele, who we will be introducing and presenting his book to the audience, we have two wonderful discussants. We have Professor Sara Iglesias Sánchez from Universidad Complutense de Madrid, and Professor François-Xavier Millet from the Université des Antilles. So the format of the event is fairly simple. Professor Gallo will present his book, both physically and theoretically, because I believe it's now out. This is a book that is really fresh off the press, or hot off the press, because I think it was published in this real world about 7-8 days ago. And so obviously it hasn't come all the way to me because of Brexit, so I don't have a physical copy. And I don't think it's made all its way to the Antilles, so François is also dreaming about it still. But I believe Daniele and Sara will have a physical copy already on show, and that's all the evidence that we need. So the format of the event is very simple. Professor Gallo will present the result of his research for the first 20-25 minutes. Then we will call upon the discussants to share their views on the book and maybe challenge the author. And then we will open the floor to questions from the audience. You are invited to write down questions for that moment in the chat, and or reserve your turn by raising your digital hand or something. I think Giuseppe will help me in that exercise. We will be particularly rigorous in keeping the time so that everybody will be on their jolly way in 1 hour and a half. And this event will be recorded. This is a fair warning to everybody, and it will appear forever on the YouTube STALS channel. And so this is your opportunity to make sure you mute your microphone at the right moment. Now, this is the time to welcome again Professor Gallo and give him the floor to hear more about this topic, which I recall is the direct effect in EU law. Daniele, take it away.
Thanks so much. So I'm supposed to, Giuseppe, tell me whether I'm wrong or not to show the book.
Yeah, absolutely. Otherwise, we don't believe you.
Go.
Okay, good. Done. Thanks so much. So we may start. And good. Can you hear me? Yeah, good. Okay. Good. So thanks so much, Giuseppe and Filippo, for the very kind invitation. Thanks so much to Sara and François for this wonderful opportunity. STALS seminars have become a key for all those studying and writing about the national comparative EU law. I'm therefore very pleased to be here with you all, albeit only online, to discuss my book, which betrays the rather doctrinal, pretty boring and old-fashioned positivism I am stuck in since I was a PhD student. So as for the origins of the volume, so the research is part and partially builds upon the theoretical background set out in a book of mine in Italian published by Geoffrey in 2018 on l'efficacia diretta del diritto dell'Unione Europea. Moreover, the OP publication is one of the main deliverables of my Jean Monnet Chair on understanding EU law in practice, EU rights in action before courts. As for the series hosting my book, it features in the OPU Law Library series alongside several other volumes related directly or indirectly to direct effect, amongst which the volumes by Leonard and others on EU constitutional law and on EU procedural law, the volume by Tritimas on the general principles of EU law, and the book by Sasha Preshal on directives. What I will do now, before illustrating a bit more in depth the monograph, is coming up with three very brief methodological remarks, if I may. So the first, I have always tried in the writing of the book to not to lose touch and with reality, and so I confess, as Filippo was saying, the book benefits also from my work as a practitioner before domestic courts and the Court of Justice, which has taught me, the whole experience very, very much, a great deal on the role played by EU constitutional law, even in cases involving technical matters of EU substantive law. So second remark, the monograph, even if published by OP, is based to a large extent on Italian, French, German, and Spanish literature, so not just on Anglo-Saxon literature, as is often the case, I believe. So there is plenty of room for continental doctrine. My third point concerns the title of the book. So the title is Direct Effect in EU Law rather than of EU Law. Why is that the case? Because the book deals with systematically the direct effect of international law within EU legal order, so not only with direct effect of EU law within national legal orders. The entire 7th chapter is devoted to such a matter. Now, let me dwell on the book more in detail. So the book aims at revisiting the past, present, and future of direct effect. So in so doing, it offers, hopefully, we'll see, a innovative, might be not innovative, so it offers an understanding, let's say, to me, a new understanding of innovative understanding, hopefully, of this revolutionary doctrine from historical, theoretical, doctrinal, and practical perspectives. So the volume explains that direct effect has evolved into a broader legal category than it was at the outset of the process of European integration in the 60s. So in this respect, the idea underpinning the book is that such evolution has not been properly acknowledged and articulated by the Court of Justice, and that for this reason, direct effect lacks nowadays a clear legal framing as to its core components and consequences. So in that connection, I wanted to reconstruct direct effect, also beyond the Van Gendel-Loss doctrine, and ultimately I tried to come up with possible solutions for its appropriate understanding and enforcement. Why is it so important to provide a sound legal framework of direct effect? Because such doctrine, as Filippo did recall, enables individuals much more than other doctrines to put into action in practice their rights stemming from EU law and seek the setting aside of national law. So this is the most extreme, complete, and radical manifestation of EU law, of its intensity, and I would say also of its uniqueness compared to international law. So the volume is divided into 4 main thematic sections. There is a first section, and this first section focuses on the origins of direct effect and on the relationship that links this principle to the principles of primacy and autonomy of EU law. So the section also dives into the interplay between direct effect and the premium ruling procedure governed by Article 267 of the Treaty on the Functioning of the European Union. In this first section of the book, I carried out, or at least I tried to carry out, a contextualized examination of the Van Gendellos case, including from historical perspective before the Van Gendellos ruling. So it is explained in this section why Van Gendellos is the result of the development in the case law which began even before the establishment of the European Economic Community, that is at the time of the European Cold Steel Community, thanks first and foremost to the work by the legal department of the High Authority, and thanks to the opinions by Advocate General Lagrange. So in this first section, I also focused on two individuals who acted as the driving legal forces of the right effect. Robert Lecour, who has been also president of the Court of Justice in the 60s, so a politician, an administrative lawyer, and not surprisingly interested mainly in the enforcing element of the right effect, the private enforcement element of the right effect. First and second, Antonio Trabucchi, so a private lawyer, the one behind Van Gendellos judgment. He was a private lawyer, a practitioner, an academic, not surprisingly interested mainly in the rights components, the individual rights components of the right effect. So as for the interplay between the right effect and Article 267, I tried to demonstrate why the Court of Justice does not only exercise a monopoly over the interpretation of new law, what we read words everywhere, but has also come to perform de facto a centralized judicial review of national legislation. And in this lies the, say, structural ambivalence of Article 267, erga omnes effect opinion rulings. Giuseppe wrote extensively on that topic on one hand, and on the other, the assessment on the compatibility of a national provision with EU law. So this as for the first section of the book, then as for the remaining three sections, they all deal with the doctrine of the right effect today. And in this respect, the volume makes basically 10 intertwined arguments, which I will briefly recall today, and they will be very apologetic, so I'm sorry for this in advance. So the first argument, the test on clarity, precision, and unconditionality, we are all aware of, is to be no longer a pillar in the conceptualization and practice of the right effect, as can be inferred from new case law, where the Court of Justice applies the three criteria vaguely and without steady guiding principles. So this is testified first and foremost by the Court's jurisprudence on fundamental rights, since a reference to the conditions of the right effect and or the test itself is frequently lacking. Second argument, clarity and precision are absorbed in the premise of unconditionality. And for this reason, unconditionality is the only true core element and condition sine qua non of the test on direct effect. So in other words, if a norm is clear, precise, it is not necessarily unconditional, while if a norm is unconditional, it is in rates clear, precise. So if there is no need for the adoption of a further internal legal act to make the EU provision enforceable, then the obligation contained therein due to its unconditional character cannot be but clear, precise. So why is it important to come up with this argument? Because this argument leads to the third argument, that is the following. So if unconditionality means that the norm is self-sufficient since it does not require an additional act of transposition, unconditionality equals direct applicability. Moreover, since direct applicability / unconditionality by absorbing the conditions of clarity and precision is the only premise of the test on direct effect and direct applicability, albeit conceptually distinct, and in spite of what is very much written in many textbooks, at least in Italy or many other countries, end up being direct effect and direct applicability in practice the same thing. As a matter of fact, an analysis of EU and national case law shows that direct effect and direct applicability often merge. So what really matters is whether a new provision is justiciable, that is applicable to the dispute at hand. So this implies that aside from issues of terminology, we discussed this issue early on with François-Xavier, direct applicability not only is a feature of regulations as foreseen in Article 288 of the Treaty on the Function of the European Union, but also of other EU legal sources, including directives, under the guise of their unconditional character. In this sense, to me, there is no difference between regulations and directly effective and implemented directives. I do not see, actually, in practice, any difference between these two acts. So the fourth argument. Direct effect is a broad notion and not necessarily associated with either the conferral of rights or substitutive effects. So it is something quite well known. So I will say it is not a very original argument. It is called invocabilité d'exclusion, which was born in the French literature. However, in the French literature, this invocabilité has been considered a form distinct, different from direct effect. Well, to me, direct effect instead has two facets. So aside from a subjective substitutive form of direct effect, there exists an objective exclusionary manifestation of direct effect, whereby a direct effective EU provision entails its application of national law without either conferring immediately an individual right or replacing the domestic norm in governing the case at hand. The works by Prechal, Pasha Prechal, have been key for the writing of the volume, for this part, the excellent monograph on directives and the at least 10 or 12 articles, depends, written by Sasha Prechal on this topic have been at the core of my understanding of broad direct effect. So indeed, advocating for a broad understanding of direct effect has evident practical implications, since it expands the scope of intervention of a doctrine of EU law as key as it is direct effect, and also the scope of intervention of the duty to disapply, which is connected to direct effect. So the fifth argument, the duty to disapply is always the result of both primacy and direct effect, never primacy alone. So this has been asserted by the Court of Justice, as we know, in clear terms, only in Poplavsky. So some scholars, including myself, if I may humbly come up with this remark, wrote this before Poplavsky, but with Poplavsky we know that it is the case. However, what is a bit striking, again back to Poplavsky, more in general, as we'll see about the case of the Court of Justice, that there are no reasons why this should be the case. So why this application should be triggered by primacy and direct effect. I believe that it is correct. However, the Court of Justice does not really reflect upon this. So in the book, I argue that direct effect ensures that the EU principle of conferral, so the EU principle of conferral and the related principle of subsidiarity are not called into question by a generalized, unrestrained use of the principle of primacy. So justifying this application on the basis of only the primacy principle has been done by many scholars over the years, the decades, is likely to undermine the logic implied in the relationship between the EU legal order and domestic legal systems, and would entail a blank proxy to the EU, which is unjustified. In fact, direct effect continues to be an essential doctrine capable of shaping, as we know, in its interaction with the principle of primacy in proto-federalist terms, the EU legal order on the other. However, it is also a sign that, albeit mature and unique in its kind, the EU is not a federal union. So that's why we need direct effect. On one hand, direct effect marks the originality of the EU, but the other hand, it also marks, it signals the mature but not complete form of proto-federalism or federalism of the EU. So the book also reflects upon when, in practice, national judges can, not must, disapply domestic laws even lacking direct effect, has been firmed by the Court of Justice in a number of rulings, including Tel and Technopark. And again, here there is no further guidance. So when actually this can happen, so when this application can occur and can be put into action and can be carried out by a national judge when we are outside the direct effect. I try to reflect also on this. So sixth argument, a paramount quality of direct effect, along with unconditionality, it is argued, is the attribution of an advantage resulting from the application of EU law and the subsequent disapplication of national law. So in other words, the disapplication stemming from EU direct effective provisions cannot be detrimental for all private parties to the dispute. That is only in malam partem, with the result that the admissibility and practice of inverse vertical direct effect shall be handled with utmost care. So we all know what inverse vertical direct effect is. The state is relying on EU direct effective provision against an individual to set aside a law that the state itself has generated. Well, so the provision of, so this is something different from horizontal direct effect, of course, because in horizontal direct effect, you have to conflict individual interests. While here you have the state invoking the direct effect doctrine against the individual. Well, the provision of inverse vertical direct effect concerns especially directives. If we all know, directives are addressed in terms of obligations only at states, so how could inverse vertical direct effect occur in the case of directives? So on this, we may say a few things. Sara knows this very well because she wrote a wonderful editorial for EULO Live with Daniel on this. So the assumption that there is indeed a provision of inverse vertical direct effect of directives, well, it's at least partially questioned by the Court of Justice in a number of rulings, especially one, Infraestructuras de Portugal, but we may go back to this afterwards. So, so directives, let's assume that as far as directives, there is indeed a provision of inverse vertical direct effect still in the case law. Well, as for regulations and those decisions that are not only addressed as states, the perspective is very much different from directives, since these are directly applicable acts. These are acts of general application published in the official journal of the EU. So indeed, once enacted, both regulations and those decisions immediately replace the conflicting domestic provisions, and they provide national legal persons with clear guidance on the rules to comply with. So as for EU primary law, so general principle EU law, charter, treaty, well, things get more complicated as far as inverse vertical direct effect is concerned. So in inverse vertical situations, to me, what I try to argue in the book, direct effect can be asserted and the duty to disapply should occur on the sole condition that the Court of Justice limits ratione temporis the effects of its primary ruling rendered under Article 267, in which it offers the Court of Justice an interpretation of EU law that until that very moment was not foreseeable. So this implies that such interpretation neither would have retroactive effects, ex nunc, nor would it apply ex nunc from the very same judgment issued by the court. So in those situations, in fact, the interpretation of EU law should be prospective, pro futuro. So from this flows that the doctrine of direct effect, to me, shall be contextualized. Brescia Le Pescatore did refer to the need to contextualize direct effect, even though they did so in respect to the test on direct effect. And so this contextualization, to me, must occur in the light of the consequence stemming from these applications for individuals. So giving the principle of legitimate expectation the role it serves, something that had not been done in Lucchini, for instance, or in Tarico 1. So again, here the works by Pescatore, Preschal, but also Bobek very much have been important for the writing of the volume, and including the opinions by Bobek, which also means Bobek and his referendaire, Sara and François-Xavier are two of those brilliant referendaires. Seventh argument. So it is possible to come up with a list of physiological derogations from the duty to disapply. So these are derogations from the duty to disapply that have been admitted, this is why they're physiological, admitted by the Court of Justice. So legitimate derogations can be advocated first and foremost when the replacement of a national provision by EU norm harms individual rights. Think of Cresco investigation, and or questions the national identities clause enshrined in Article 4.2 of the Treaty on the European Union. So there are, of course, a number of physiological derogations I try to come up, I try to sketch out, try to sketch out in the volume. And there are also other pathological derogations I focused on in the book. So eighth argument is on horizontal direct effect. Filippo, of course, just tell me whether I'm speaking too much or not.
No, you're good. We still have about 5 minutes if you can try to wrap up in 5.
Good. So eighth argument on horizontal direct effect, most notably, but not only about directives. So in the book, I argue, in line with what has been written by several scholars, including in very clear terms by Bobek recently, argued that recognizing directives horizontal direct effect is a more suitable route than the judiciary-based stratagems designed by the Court of Justice to bypass its prohibition, so the prohibition of horizontal direct effect of directives. So the principle, not only, yet the principle to me, reason for this recognition is the protection of legitimate expectations. A principle with, actually, if I'm not wrong, a principle that is often neglected when one challenges the prohibition of directives horizontal direct effect. So in fact, such principle, in addition to be relevant from the point of view of the person who conducts oneself in accordance with national rules contrary to EU law, it is the main narrative, right? Principle legitimate expectation, this is why directives should never generate a horizontal direct effect. Well, this principle is also relevant from the point of view of the person who complies with a EU directive that has not been transposed into national law, notwithstanding the expiration of the transposition deadline. So the paradox resulting from the provision of horizontal direct effect of directives is that the party who acts in conformity with the directive is always at a disadvantage compared to the party who acts contrary to the directive, but in conformity with national law. So this is a paradox that does not occur in the case of inverse vertical direct effect, where one party is the state and the other is a private party. So, to me, relying on its jurisprudence on the prohibition of inverse vertical direct effect, as the Court of Justice systematically does, to justify the prohibition of horizontal direct effect, to me, is a nonsense, is a bit, basically, it's wrong. So, my opinion is that to always let prevail the interest of the individual who has acted in accordance with the national provision which conflicts with the directive is not the best solution. On the contrary, it may well be claimed that the interest of the person invoking a directive, that is a source superior to domestic law, should normally prevail over the interest of the person invoking a national rule that infringes EU law. Again, the principle of legitimate expectation here is very, very important. Ninth argument about the direct effect of international law within EU law. So basically what I argue in the book is that the Court of Justice narrative or legacy on the direct effect or lack thereof. International law within the EU is political. It is not tenable in legal terms. It's not really even understandable sometimes why some international law provisions are considered deprived of direct effect by the Court of Justice. So there are several points. The first point is that the narrow conception of international law's direct effect within the EU legal code advocated by the Court of Justice, imbued with connotations related to the conferral of rights, is not legally justified, since the conferral of rights is not always a precondition for direct effect. First. Second, the choice to rule out that the very famous Fediol-Nakajima doctrines constitute a form of direct effect, albeit being both a means of legality review, which had little in common with indirect effect or consistent interpretation, is also a political one. So Nakajima and Fediol, to me, are a form of direct effect, exclusionary direct effect, but still it is direct effect. So why ruling out direct effect in the case of these two doctrines? Third argument, the appreciation of direct effect as a precondition for challenging UX is also political. So more specifically, the Court of Justice has been increasingly denying the possibility for individuals, companies, and states to challenge EU measures by virtue of international law. Okay? Why? The Court of Justice did so in order not to subvert, to challenge the institutional balance and the separation of powers between the judiciary on one end and both the legislature and the executive power when they manage external policies. Good, but again, to me, this doesn't make much sense because annulling proceedings, so challenging UX, do not presuppose the right effect. So why is it the case when we are facing international law? So the right effect of international law or lack of the right effect of national law within EU law? Well, because we are in the realm of politics rather than of the law. Lastly, the book also deals very much with the diminishing role of the Court of Justice as a gatekeeper for the judicial review of international agreements due to the current practice, as we all know, of the EU and its partners to include in the text of agreements, especially trade agreements, clauses that explicitly preclude the direct effect in the EU as well as in the member states as well as in the level of the member states could be asserted. So 10th conclusive argument, 40 seconds. So the jurisprudence of the Court of Justice is imprecise, unpredictable to me, too minimalist, and at times inconsistent. And so here comes the argument. So this form of judicial self-restraint, this form of argumentative minimalism is as problematic as judicial activism. So when at issue are fundamental principles from which other principles, rules of reason, legal taxonomies are derived, judges should always use the best efforts to understand, intercept the legal concepts and legally frame them. So to this end, I conclude the attempts outlined in the book, in the 7 chapters, aim at identifying what I believe are possible solutions to strengthen the twofold ability of the direct effect to do what it should do, safeguarding individual rights, first, Trabucchi, and second, ensuring the private court enforcement of EU law, Robert Lecour. Thanks so much. Thank you. Thank you very much.
Thank you very much. Thank you very much, Professor Gallo. That was a mouthful, but thanks for trying to summarize all the various aspects that you covered in the book. And I'm glad it's not my job to try to deep dive into this, but we have professionals for that. And the first of our discussant today is Professor Sara Iglesias Sánchez. She will have 10 or maybe even 12 minutes to share with us views on Daniele's talk. Thank you very much, Sara.
Thank you. Thank you so much, Professor, for the introduction. And thanks also a lot to the two organizers from STALS, Professor Martinico and Professor Deledone, for making possible a discussion on what I confirm it's an imminent classic of the literature of EU law. And I will be torturing generations of students with it in the future, most likely. But most of all, congratulations to Professor Gallo for having finally produced. I have here the copy, in spite of the duties of it coming from Brexit UK. It's really impressive to see it in paper, even more than it was before when we were discussing it. I must make here a disclaimer. I have been discussing with the author quite a lot. I had the chance to be sitting next to his office, the chance or the misery, because every morning, even before or with a reflection on direct effect. And when I read the very kind message to his family in the first page, I can totally attest that he was waking up with the book and probably ending his days with the book, because the intellectual curiosity that generally was charging his thoughts was really contagious. It got into me, and some nights I couldn't sleep thinking about direct effect. So this is something that really shows in the book. This intellectual curiosity, which charges every page, is really astonishing, and it's a genuine curiosity and a very brave way of explaining his doubts and all the problems that surround this very complex notion of EU law. And precisely because of that, the book is so original, because this is a very old-fashioned topic. If somebody will tell me now, Sara, can I write my PhD on direct effect? I will say, forget about it. Everything has been said. But and there will be done, and a lot of systematization, because the concept is indeed not only complex but problematic in its application, both by the Court of Justice, let alone national courts, which are often alone and which often resolve direct effect problems on their own, trying to follow a guidance that sometimes is not so self-evident. So I'm not going to go through the structure of the book. Professor Gallo already did so very eloquently in his presentation, going directly to the conclusions of the book, which really systematize in a very clear and very to the point manner the main points, the added value of the book and of his thoughts in these 10 ideas. But it is to be also under or stressed that every of the chapters in its own, it could be an article, right? Because it has a clear thesis, it has a clear way or construction, a clear argument. And for me, my favorite points are where he unfolds or tries to open up the melon of the test of direct effect. Because for all those who have had the fortune or misfortune to have to deal with this in practice, this is one of the topics that makes one's head spin around. The application of the test, what is the difference between clear and precise, if there is any? And Professor Gallo very clearly tells us this is all nonsense. What matters is unconditionality. And it was like the sky opening up to me. I was like, yeah, probably he's right. Probably he's right when applying this test in practice. And it is so when you look at the latest case law and some rulings that appear contradictory or that do not fit with the application of the test in the past, start making sense when you look at them from this perspective. I was a couple of days ago speaking about labor, and first preliminary ruling ever asked by Spanish court, which Professor Gallo mentions in his book, Sara, the court said that Article 2 of the treaty was an example of a rule that could never have direct effect because it was too general. And now we are embarked in trying to discern the applicability and the justiciability of Article 2 TEU, which is even probably broader than that. So from this point of view, this new framework that he offers, I believe is going to be very helpful, not only for academics, because this is an academic book with a lot of depth, an academic depth on it, but it is also a book for practitioners, because I believe that Professor Gallo couldn't avoid continue being a practitioner himself when he was approaching the real life problems of how this concept is to be applicable in real cases. It is from this point of view that the book is also very valuable when it comes to have a combination of the history of the concept, the people that were participating on it. He's very sensitive to the political change of times as well. But most of all, he's looking at it as a lawyer who has been dealing probably with cases where he had to deal with real life problems of direct effect. And this is where the book becomes more valuable, because it's not only theoretically thick, but it goes to the practicalities and the conclusions that he summarized, which are also the conclusions of the book, have a very important practical implication, which is, if I may borrow the style of Professor Gallo, he likes to put adjectives to direct effect. We could see a transformation from this first emergence of the concept that we could label as existential direct effect. So the court was creating this as an existential need for the emerging legal order, and it was completely instrumental to the creation of EU law as we know it today. But today, from the point of view of the maturity of the legal system, we could look at direct effect as something more like not so much existential. We can contextualize it. I will say that he uncovered a contextual direct effect, which is not so monolithic, where the test or the conditions or even the unconditionality test depend not only on the provision or on the part of the provision, but on the role that it plays in a given legal situation. And that is why what is particularly valuable for me is how he tries to reconstruct and explain how directive needs to be balanced in a more mature legal order. This is what he was explaining as how in vertical or in relations, when the direct effect of rules other than directives is at stake, then we need this this idea of only pro futuro direct effect, because we are here balancing more effects. We don't need to be so obsessed with the efficiency of the EU legal order, because we have many more elements to balance with: fundamental rights, legal certainty, legitimate expectations, and so on and so forth. So for me, he has uncovered the red line of the evolution, not only of the principle, but of the legal order itself, using direct effect as the way of uncovering how the system has or it's in the path of becoming a more mature legal system. I don't want to steal more time from the discussion, just to congratulate the author again. This is a book that is truly a pleasure to read. I've learned a lot about history. This is one of the books that combines a kind of history told in a way, not gossip-like, but a little bit, so that you really get trapped into this and you enjoy learning about the past. Might be theoretically very interesting, but it's law that needs to be applicable by judges, by lawyers, and understood by students. So this might provide a very good guide for future discussions, for explaining direct effect, and who knows, probably for courts, maybe even the Court of Justice, to continue future discussions on this. Thank you so much.
Thank you very much, Sara. That was a very nice and well-rounded intervention. And we, of course, agree that this is a great book, but maybe somebody thinks differently. So maybe Professor François-Xavier Millet will have something else to say. And the only way to know is to give him the floor. François, are you with us? And if so, please take it away.
Thank you very much. Can you hear me?
Yes, we can very well.
Yes. Okay, wonderful. So apologies, first of all, for not turning on my camera, but so I am like the otherworldly voice from across the Atlantic who has perhaps some instability with his internet connection, and hence it's preferable if I do not turn on my the camera. So as long as you hear me, it's all fine. Thank you very much for the invitation to Giuseppe Martinico and Giacomo Delle Donne, that I'm also very happy to meet up, albeit virtually, on this occasion. And I obviously concur with what has been said by Sara Iglesias, my dear colleague from and friend from the Bobek cabinet, from the Bobek time, which is now over, unfortunately. And so I can only concur with her on the fact that it's a major book, that one might think on a superficial approach that everything has been said about direct effect indeed, and that there is nothing original that can be done out of it. And Daniele Gallo shows the contrary, shows the opposite, shows actually how timely this book is to do somehow the state of the art, not only the past of direct effect, but also the present and the future. And I absolutely love the book because it is rich, it is very comprehensive, and it bears the mark of someone who is a great academic and a great practitioner at the same time, and who manages very, very to combine those two skills as an academic and as a practitioner in this book. And of course, this book, again, Direct Effect, I was presenting Van Genden laws to my third year students only a couple of days ago. And Van Genden laws and direct effect, it's in themselves not overcomplicated to explain to students. But it's all the follow-up of Van Genden laws up to the present day that show that direct effect is an absolutely daunting concept of EU law, and that there's nothing clear about that. And as Sara said earlier, I would not necessarily encourage many colleagues and our fortiori students to engage into direct effect. And Daniele can only be praised for having had the force and courage to engage in those in that concept, which gives a lot of food for thought. And I will focus on the present and perhaps also the future, as Daniele invited us to do in his conclusion. And that I'm not sure that I would play, because right now it seems Filippo Fontanelli has invited me to be the bad cop, and I don't want to be the bad cop. Although it seems that okay, I'll be a nice bad cop, basically. And I would like to discuss more three issues. The first one is the conceptual fuzziness of the concept of direct effect itself, which is uncovered by Daniele Gallo in his book. The second aspect I would like to address very briefly, all of them, of course, are the knock-on effects of that conceptual fuzziness on the EU legal order and on other EU legal instruments. And finally, I would like to question actually the uniqueness, the famous uniqueness of EU law compared to institutional law when it comes to direct effect grasped in such as a very fuzzy concept. As to the first point regarding the conceptual fuzziness, here, of course, I I've been educated, I've received lessons, courses in EU law myself from a French perspective. And Daniele mentioned in his presentation and in his book, of course, that in France, we used to present in a very clear manner the distinction between exclusionary effects and substitutive effects as the consequences of direct effects, but precisely as exclusionary effects being a mere consequence of primacy, irrespective of direct effect, and substitutive effects, which would be the added value of direct effect. And Daniele shows in a very compelling manner that it is not the approach that the court has endorsed. And the court made it very clear in the second Poplavsky judgment. And the second Poplavsky judgment is still something that personally I do not really grasp, and that many colleagues, especially in France, but also abroad in other EU member states, specialized in EU law, experts of EU law, that do not fully understand. Because it seems that really the added value of direct effect was precisely the conferral of rights and the possibility of plugging in EU law provisions into national law and to have a positive application, substitutive application of EU law to the detriment of national law, but to the advantage of the individual invoking EU law. And this is all gone. This seems all very fuzzy, as I said. It's all very fuzzy because as it's explained very well in the book, and I concur with Daniele Gallo on that, and on many other things, direct effect seems to be now conflated with direct applicability, with unconditionality, and direct effect would precisely not be that unique or distinctive anymore if the conclusion of the consequence of a directly effective provision of EU law is not substitutive effects, but it's exclusionary effects. And I think that I wonder whether it was really what was contemplated by the court at the very beginning, and whether the court actually is fully aware of what it is doing in that respect. So, of course, we can try to map out, perhaps that would be another option for further research. It's just to try perhaps to determine whether an EU law provision, directly effective one, has exclusionary or substitutive effects by looking at the configuration of the case before the national court. In the sense that we can also distinguish probably I'm raising some options here, between the abstract review of compatibility of national law with EU law and some subjective review, which would also have different consequences. I would imagine also that everything depends on the type of the content of both the national measure in issue and the EU measure. If it's a prohibition, it's obvious that then the duty to disapply, being also negative like prohibition, would be to ensure the effectiveness of the directly effective EU law provision. But if it's like a provision of EU law that provides for a right, for a concrete right, then probably it should be associated with some sort of substitutive direct effect. So I would assume, at least. So this is a first aspect, the conceptual fuzziness. The second aspect I would like to address are the knock-on effects of that fuzziness on other aspects of direct effect, and more broadly on legal instruments. And here I'm also obviously referring on the horizontal direct effect of the directives and also of the charter, because as we know, both are connected. And when it comes to the horizontal direct effect of directives, Daniele Gallo makes a proposal that I'm not sure to second about the need to accept the direct effect of horizontal direct effect of directives, and he claims that directives, unimplemented directives that have direct effect on regulations, have no difference. I agree that somehow it would be much easier to accept horizontal direct effect of directives instead of what he calls the judicial stratagems. That's clear to me. But at the same time, directives are essentially, and it's been conceived in the EU legal order as an essentially different tool than regulation. How can then, because it's what the court is doing, I agree with Daniele on that, it's what the court is doing, but should we second the court? Should we follow the court and embrace its position by accepting that there would be no longer any difference between a directive and a regulation? I agree also with this aspect that perhaps a directive that creates an advantage for the individual should be taken into account, but one should not forget that the case law from Becker onwards, Ratti and Becker, was created about horizontal direct effect of directives as a sanction on the member states, certainly not as a sanction on individuals, and giving a privilege and precedence to the position of having an advantage deriving from a directive. And enforcing that advantage necessarily means that you enforce it against another individual, in that case, a private undertaking. That it's used as a sanction of a private undertaking to somehow remedy the shortcomings of the member states. So I'm not totally convinced by that. And I think that there has been a reason why directives and regulations have been distinguished. And I agree that there is increasing convergence, but where would that convergence stop? Shouldn't it stop at some point, that convergence between regulations and directives, which are essentially two different tools? Shouldn't we just expect nowadays from the EU institutions, if they want to have some kind of horizontal direct effect, well, institutions just go for regulations, just drop directives. Why using directives then instead of regulations? That's the major issue that concerns the EU legal order as a whole. And my third and last point, will be much briefer, don't worry. It's about the uniqueness of EU law. As we know, the doctrine of direct effect, together with other doctrine, has been classically the hallmark of EU law. It has characterized, I won't dwell into that, but it has characterized the autonomy of EU law, and especially vis-a-vis international law. And it's a topic that I'm really wondering about, I've been wondering about recently. Is there anything unique nowadays, direct effect in EU law compared to international law? International law where there are increasingly directly effective provisions? So what is then distinctive of EU law when it comes to direct effect? Since international law itself has evolved, it has been constitutionalized towards also a possible conferral of rights to individuals by international law. So what is nowadays unique? And what is all the more unique in EU law about direct effect when such a concept seems so unclear, so fuzzy? And on that, we can, and on many accounts, we can just welcome Daniele Gallo's book, which is extremely timely to show that fuzziness and pave the way for future research, because that shows yet again that direct effect needs further research on the part of EU lawyers. Thank you very much. And again, congratulations on Daniele.
Xavier. Now, thank you very much. And I'm a bit confused because I'm not sure whether we needed further research and now Daniele has filled that gap, or we need now further research. I think we need to decide what is what. I think now everything has been written. This is my position, at least, okay? So don't do any research on this, please, for at least another 6-7 months. Now, we don't have, so I invite everybody in the audience, if they want, to either reserve their time for question or write a question in the chat. While you do that, I'm asking whether Professor Gallo would like to address the very comprehensive and kind comments raised by the discussants in a relatively brief way, but maybe this is the right time to do that. Do you agree, Daniele?
Yeah, you tell me, Filippo. Should I do it now? Yes.
Yes,
Okay.
I
Okay.
would do it so we can collect something else if it comes by, but
Okay.
try to stay within, 5-6 minutes altogether.
Yes, 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 thanks.
Thanks.
Okay, so thanks so much to Sara and Francois. Yes, in a way, we have been discussing this issue, Sara, quite a lot while you were in Rome, and I apologize for that. And I did also the same with Giuseppe, Filippo, and Francois, actually. And Sara was also very kind to do an endorsement on the JPEG of the book alongside some other colleagues. So thanks so much, Sara. Again, that's the occasion to thank you once again. And yes, I think that you did pinpoint to very important points I wanted to make in the books. First, that direct effect must be studied, at least to me, by looking also at the practical implications of direct effect of the doctrine, which means that we should look at how direct effect plays a role in the case at hand, the actual case at hand, and by looking at the implications for the individuals, by looking at how the test is carried out. And you're right, I mean, national judges are completely lost as far as the test is concerned, and as far as the difference between direct applicability and direct effect is concerned. If we look at the rulings by our Constitutional Court, when we very easily grasp what you told us, because then in the end, the Constitutional Court in Italy refers to direct effect by using the term direct applicability. It does so all the time. There was a very good article by Onida on that, but it is clear, just then in practice, they mean the same thing. And yeah, so thanks so much on that. And I agree with you. Article 2 of the Treaty of the European Union, well, the justiciability of this provision is a hot topic nowadays, but well, of course, if we consider this provision to be directly effective, we will then consider many other provisions to be directly effective. So this is the truth, and let's see whether this provision will be considered directly effective alone by itself, or with Article 19, with Article 47 of the Charter, because now at least I know that there's been a hearing before the Court of Justice, a very important case recently, where the Commission did come up with the idea that Article 2 should be considered directly effective by itself, not with Article 47 of the Charter, Article 19 of the Treaty of the European Union. So let's see what will happen in that respect. But of course, this shows to a great extent to what extent direct effect is a transformative notion, transformative concept, and to what extent direct effect evolves over the years very much. And yes, what I try to do, and again relying also on the work by Perchal, by Bobek, by Pescatore, and by others, what I try to do is dwelling on a doctrine that to me, that should be contextualized, that should be seen in context. So to me, direct effect is not a predetermined quality of a provision, and direct effect is much more than that. So that's why also the principle of legitimate expectation is so important when cases such as Tarico, Lucchini, many others are at stake. So thanks very much, Sara, to François. Very important point, of course. Well, invocability d'exclusion, yes, and the fuzziness of direct effect as far as Poplavsky, the narrative and the legacy stemming from Poplavsky is concerned, what François referred to. Well, to me, François, the minute you argue that this application, that exclusion is the result of primacy and the direct effect, well, you must accept the idea that invocabilité d'exclusion is a form of direct effect. So the minute you argue that this application, and rightly so to me, is the result of primacy and direct effect, like in CIA or like Unilever, well, invocabilité d'exclusion becomes a form of direct effect, because in those cases you have indeed this application. So I would say that the reason why the Court of Justice made that move and took the stance in such clear terms in Poplaski relates to this, to justifying this application in those cases. And well, to me, the minute you argue that there is such a form of direct effect, then, well, there are so many things to be said on the potential of direct effect as a broad legal category. Well, the fact that the category is broad doesn't mean that it's fuzzy. I mean, I don't know whether there is really a link between the two. Yes, it has to do with it. This is true. It relates to the uniqueness or originality, which we are challenging a bit of direct effect. But that's, of course, something different. An example, what about the principles in the Charter, so the distinction between rights and principles? Well, to me, if you accept an exclusionary form of direct effect, why not admitting a direct effect in respect to principles, not only to rights? And if you argue that, and if you assert that Article 2 of the Treaty of the European Union is direct effective, why shouldn't principles be considered direct effective as well? That's just an example. And then, so why to me there isn't such a structural link? There isn't such a structural link between conferral rights and direct effect. Because direct effect, on one end, is about conferring rights. Substitutive, subjective, direct effect, Van Mendelhoff's doctrine, and so on and so forth, Trabucchi. But then it is also about enforcing rights. It's also about the private enforcement of EU law. This is why inverse virtue direct effect is admitted. Not to respect the directives, but it is why the Court of Justice admits inverse virtue direct effect. Here there is a state, actually a state, invoking a EU provision against an individual. The right element disappears completely. Or you have other judgments, other rulings, the one about seaside concessions, for instance, about concessioni balneari. Well, there you have a state administration, the Italian Competition Authority, invoking direct effect against another state agency, il Comune di Ginosa. And it is about direct effect. So it's about the state triggering this application of its own national law. So direct effect is not only about rights, but it's also about enforcing EU law. So this might explain a bit why the Court of Justice had been so bold in Poplaski. Then directives, yes, I see your point, François, but then again, to me, there is no difference between a regulation and an implemented self-executing directive, which means that to me, directives, which are acts that are published in the official journal of the EU, it wasn't the case before. It is not really novelty, but it happened, I think, 35 years ago. So directives are acts published in the official journal. To me, they are directly applicable when there are unimplemented statutes in the directive. So, to me, the equivalence between regulations and directives stops when a directive does not comprise self-executing provisions. If the directive, as it is quite often the case nowadays, we know, when the directive comprises such provisions, to me there is no difference between a directive, an implemented directive, self-executing directive, and a regulation. So this is why, to me, it would be much preferable to admit the horizontal directives rather than coming up with this very weird stratagems that the Court of Justice designed in the last few years. And yes, very good. That's very, very interesting point, the one you make about the originality of EU law. So is it possible to consider EU law original, unique, due to its direct effect, if the direct effect is such a fuzzy doctrine? I mean, that's interesting. What we might argue is that still a difference is quite evident between international law and EU law as far as direct effect is concerned. So direct effect, within EU law, there is a presumption of direct effect, and it is up to the Court of Justice to decide whether EU provision is directly effective or not. Within international law, things are different. I would say there is an inverse presumption of direct effect first, and second, it is up to national legal orders to do so. I mean, to make the assessment on the internal effect of that very international provision. Okay, thanks so much. Sorry, I've been too long, probably as usual, but it's always the case with me. Sorry.
That's wonderful. Thank you very much, Daniele. That's fine. Now, this is the time where I turn to the audience and I ask to raise comments or questions. We don't have a lot of time. We have 15 minutes, so it's best that we go forward with some courage rather than hesitate, because then the time is upon us. So I'm calling on everyone in the audience, but also our gracious guests, Giuseppe and Giacomo, if there's anything they want to add or ask to Daniele or the discussants.
Yeah, sure. If I may, because I don't
Sure.
see other participants interested in asking questions. Well, thanks so much. I think it has been a fantastic webinar. I learned so much. I enjoyed the book. I think the book is really fantastic as it manages, I mean, to show how that direct effect has evolved. And the direct effect is not a static concept, so but it is a concept that has evolved over the years. I also like the distinction between the section devoted to internal and external direct effect. In this respect, I remember Advocate General Tepoyares Anduro's opinion in the Fiam and Fedon case, in which he emphasized the existence of two different concepts of direct effect and the existence of two different tests concerning direct effects. And now I have some questions for Daniele. First of all, I remember a very interesting opinion given by the Advocate General both to the Cuckoo Deveci case, in which he stressed the existence of some palliatives. He called them in this way to remedy the flows, due to the absence of horizontal direct effect to concern the directives. Now, he mentioned, first of all, consistent interpretation, secondly, the Frankovich doctrine, and thirdly, what he called the disconnection. He said that the third palliative consists in disconnecting the horizontal direct effect of directives from the right to plead them to exclude contrary national law in proceedings between private parties. And my first question for Daniele is, do you think the description is still accurate? First question. Second question is, I think that we are still paying the price of the mangled doctrine. So I still see a lot of mangled doctrine around. For instance, when reading a case which has a very complex name and very complicated, for me, discriminating son. Oh, Diskriminering Ombudsmannen versus Brotens Regional Aviation. I'm sorry for my very bad pronunciation. Well, in this case, we don't understand, I mean, whether direct effect is granted to the Charter of Fundamental Rights provision in Article 47, or to the combination of two different provisions. So the Charter plus the directive. And this would be the mangled scheme 2.0 adapted to the combination of the provision of the Charter and the provision of the directive. And we don't understand whether this is a strategy to mask a sort of horizontal direct effect acknowledged to the provision of the directive. What do you think about that? Are we still dealing with the legacy of mangled or not? Thanks so much. I really enjoyed the debates, and I hope there will be other questions after that. Thank you so much.
Daniele, do you have a comment or answer to Giuseppe's point?
Yeah, so very brief, but this time, sure. Yes, I will be very brief. Very good point, of course, Giuseppe, the one on the palliatives. That is how I confirm what refers to as the stratagems designed by the Court of Justice to bypass the provision of horizontal right effect. I think that, well, it was accurate, of course, but then with Poplavsky, things did change because basically, in this opinion, if I'm not mistaken, Bob very much focuses on one stratagem, one avenue that is considering that the invocabilité d'exclusion, the exclusionary form of internal effect, is not a direct effect. So basically said, well, in Chia, Unilever, so in all those judgments, there wasn't direct effect. The exclusion shall be considered as a result of primacy alone. And by saying that, it justified the internal effect of directives in horizontal relationships. But then the minute with Poplavsky, the Court of Justice argues, concludes, first argues a bit, not so much, then concludes that this application is always the result of primacy and direct effect. You cannot come up with this stratagem anymore, because that the form of exclusion is indeed a form of direct effect, and here comes the horizontal direct effect of directives. Okay. First, second, it is a mess, and what the Court of Justice is doing, or more in general, it is a mess what we have in respect to the role played by the Charter in combination with the directive. So here we have here with us today experts who wrote very much on that. Fien van Rens, for instance, and she wrote a wonderful article on a recent case by the Court of Justice on that. And it is a mess. And well, in some rulings, what I try to argue in the book, this quite long chapter of the book, it is a mess. Why? Because in some rulings, the Court of Justice seems to tell us that this application is the result of the Charter itself, while in other rulings, much more frequently, the Court of Justice keeps combining the Charter with directives. But again, of course, Giuseppe, to me, it is one of the stratagems used by the Court of Justice not to assert the horizontal directive of directives. But then, why? Because then, in practice, this application is setting aside, and the substitution effect stemming from the application of your law lies in the directives rather than in the obscure charter provision. Thanks, Giuseppe. I'm done.
Wonderful. Thank you, Daniele. Now,
Thank you.
we are at a crossroad because our time is almost over, but we would have a few minutes for questions. So there's no pressure either way, but it is my duty and interest to ask again. Oh, we have a wonderful question by François-Xavier, and assuming there may be some connectivity issues, I will read it out to the best of my abilities. Now, at the conceptual level, if direct effect, direct applicability, and justiciability are ultimately one and the same thing, what is then the added value of a directly effective provision compared to a non-directly effective one? Wouldn't the logical conclusion be that any provision of EU law shall be fully justiciable and does entail the duty of conform interpretation, the duty of awarding damages, and the duty to disapply, all three of them at the same time? And we also have another question by one of our listeners today, and I'll read that as well, so that afterwards I will call upon Daniele to answer. We actually have three in a row, okay? So François-Xavier was one, and please start formulating an
Filippo,
answer.
if I may ask if they want to open their mic. I mean, this will save some time.
Yes, so we have Oriana Balsamo, and then, of course, Clara and Letizia Labus. If they want, they can ask the question directly. Otherwise, maybe they are fascinated by my playing out, and they want to pursue that, maybe.
Good afternoon. Can you hear me?
Yes, we can, Oriana. Please go ahead.
Thank you for your enlightening contribution and for your intervention today, and also to Professor Gallo. Just really briefly, I was wondering, in light of Investituras de Portugales and also Energotenica case, if there is a need to do further research on inverse vertical direct effect, and specifically also to see whether the Court of Justice will be more explicit to exclude this possibility in future case law. Thank you.
Thank you very much, Oriana. And now maybe if Clara wants to raise a question so that Daniele can answer all three and give us the good night.
Yes, sure. My connection is bad. I hope you can hear me. So
we can hear you very well. Thank you, Clara.
Perfect. This is an issue that I am working on, as Professor Gallo knows. So I'm very curious about the future of external direct effect, because you mentioned already the doctrines of Fediol and Akajima, and that, in your opinion, they are forms of direct effect. So I was wondering if there are any other cases apart from the Kaikai judgment last year that maybe we could use as an argument for this line of reasoning, or if there's any other trends that you see in this direction. Thank you.
Thank you very much, Clara.
Okay.
Daniele, first of all, you take responsibility for talking about Kaikai, and then we want your answers on these three comments or questions.
Okay. So the last one, I'll start by answering the point raised by Clara. To my knowledge, no, not really. I mean, Kaikai is a confirmation of this fuzziness defining external direct effect as well as internal direct effect. To me, it's not clear at all. I mean, it is very much clear that Fediol and Nakajima are forms of a legality review. It is very much clear from what we said that the exclusion is a form of direct effect, but then to me it is not clear why we are not in the realm of direct effect in a case such as Kaikai. But so to my knowledge, there are no further cases which might enlighten our research. Oriana, thanks very much for your question. Yes. So again, Sara knows the case very well. the piece with Daniel was really very, very good. And there is also a nice blog post by Sánchez on this ruling. Well, this ruling, why is it so important? Because here basically the Court of Justice openly states that it is possible for an administration, the case at stake is administration dealing with public procurement, stuff like that, to invoke a directive in order to set aside the national law that wrongfully implemented the directive in view of excluding a private company from a public tender. Well, there is, to me, inverse vertical direct effect applied to directives, where you have a state agency, administration, invoking a directive in order to exclude a company from a public tender. Okay, so that is, I mean, this is serious because basically here the Court of Justice is doing a ruling on what the Court of Justice kept telling us for decades and decades about the provision of inverse vertical direct effect applied to directives. Then François, I partially see your point, but I do see your point a bit. Yeah, to me, consistent interpretation and state liability are two different things. So the fact that we do consider the invocability exclusion as a form of direct effect doesn't mean that the boundaries between this form of remedy is equivalent to equal state liability and consistent interpretation. These are two different things, three different things. Why? Because what is the distinctive feature of direct effect is the setting aside of a national law, something that doesn't pop up in respect to state liability or consistent interpretation. But again, thanks very much for your comment. I will reflect upon it.
Thank you very much, Daniele. And so will we reflect upon the numerous ideas and suggestions that we heard from our wonderful speaker and author today, our brilliant discussants. And so I hope you can join me in thanking Professor Gallo, Sara, François, Giuseppe, and Giacomo for helping having this wonderful event, which finished precisely on time. So our efficiency is sometimes even better than the efficiency of the Court of Justice.
Thanks, Filippo.
Thank you very much. And we say thank you and farewell to all of you, unless Giuseppe wants to add anything